Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
He pointed out that both Premier and Doshi holdings have been described as borrowers in the loan cum pledge agreements. Stop. Mr. Saxeria also pointed out that Doshi Holdings had acknowledged receipt of monies disbursed under their loan agreements by executing loan receipts. Stop. Doshi Holdings had also issued demand promissory note unconditionally promising repayment of loan to the financial creditor. Stop. The loan agreements, receipts, and demand promissory notes have been signed by the appellant in his capacity as the authorized signatory / director of Doshi Holdings and Premier. Stop. After Premier defaulted in payment of loan, demand notice was issued to Doshi Holdings to repay the loan in its capacity as co-borrower. Stop. Mr. Saxeria argued that the definition of financial debt contemplates a disbursal against consideration for time value of money and not a disbursal necessarily to the corporate debtor. Stop. Otherwise, an amount payable under a guarantee could never have been included in as much as amounts are never disbursed to a guarantor, but he is liable for debts of another. Stop. Mr. Saxeria further argued that the definition of corporate debtor does not require as a precondition that monies should have been disbursed to the corporate debtor. Stop. The sine qua non for an entity to be considered as a corporate debtor is that such person entity should owe a debt to any person and not that a disbursal has to be made to such a person / entity. Stop. Mr. Saxeria submitted that Doshi Holdings satisfies the aforesaid criteria inasmuch as it is a co-borrower in terms of the loan agreement under which monies have been borrowed by both Premier and Doshi Holdings. Stop. Both Premier and Doshi Holdings have executed loan receipts, admitted receipt of loan amounts, and demand promissory notes unconditionally promising to pay the monies borrowed to the financial creditor for value received. Stop. The mere fact of it also being a pledger is wholly irrelevant and does not in any manner disentitle the respondent number 1 to initiate proceedings under section 7 of the IBC against such a co-borrower. Stop. It is not in dispute that the financial creditor disbursed loan to the tune of rupees 6 crore to Premier pursuant to the loan cum pledge agreements referred to above, executed both by Premier and by Doshi Holdings. Stop. Doshi Holdings has been referred to in the agreement as borrower and pledger. Stop. Prima facie, it appears that Doshi Holdings was a party to the loan cum pledge agreement in its dual capacity of borrower and pledger of shares. Stop. The appellate authority has arrived at the factual finding that Doshi Holdings is also a borrower under the loan cum pledge agreement. Stop. The factual finding of the appellate authority, which was the final fact finding authority, ought not to be interfered in this appeal. Stop.